Welcome to Canada's most irreverent talk show. This is the Andrew Lawton Show, brought to you by True North.
The government told us all, maybe they didn't even know it was a lie at the time, that we could buy our normalcy with 2 doses of a COVID vaccine. And then it's 3, and now it's 4. And now the transition from fully vaccinated to up to date is a very insidious one, because it means that all of these restrictions that they've suspended now, like the vaccination requirement for avoiding quarantine when you come into the country, they're all going to come back. And when they come back, they're going to have a new definition. And all of a sudden, the realm of the unvaccinated will just balloon to a size it hasn't been since 2019. And I want to, just along that vein, turn to ArriveCan here, which has become, as people travel, as more people leave the country and for some reason come back into it, has become something that more and more Canadians and foreigners are facing. And it's this app that the government originally thought would be a pandemic management app. It felt like it was an easy way for them to get people to give their vaccination certificate when they come in, and it saves time at the border and saves time with the public health officials and all of that. And now they're making it a permanent fixture in entry. So I'm glad to see it's being challenged, not just by Canadians that are not complying and are taking huge fines as a result, but even in the courts. The Justice Center for Constitutional Freedoms has filed a legal challenge, a charter challenge against ArriveCan. And JCCF lawyer Sayeh, Hassan, and Eva Chipiuk join me on the program live. Sayeh, Eva, it's great to talk to you both. I'll ask, I don't know which one of you wants to take it first, but what is this case about? Because it's one thing to not like ArriveCan, it's one thing to find it annoying, but fundamentally, what is it that this challenge is going after?
Thank you, Andrew, for having us on your show. And I guess I'll go first. And I want to talk about what this case is not about, because we have seen so much division in our society, vaccinated versus unvaccinated. This case is not about whether you're vaccinated or you're not vaccinated, because the ArriveCan applies to everyone. And even if you're fully vaccinated, but you choose not to use ArriveCan because of privacy concerns, you're still going to be compelled to quarantine for 14 days. You're still going to be given a fine of $5,000 or more. So it's really important, I think, to point that out, that this is not a case of whether you're vaccinated or not. This impacts all Canadians. And one of the major concerns of a lot of our applicants and Canadians is the privacy aspect. And we have applicants in our case that are fully vaccinated who simply don't want to use ArriveCan because they're concerned about privacy. We don't know what's going to happen to this data. We don't know who has access to it. We don't know who's storing it. Where is it getting stored? This is a major concern for Canadians, and that's the kinds of questions that we're going to be asking the court to answer.
I think the privacy aspect is key. And I'll ask you about this, Eva, because I know that when I have come into the country and I've used ArriveCan, basically it's tied to my passport or my Nexus card. So when I scan that at the point of entry, they already have my ArriveCan. So it's in a database, and it looks like the government has done a fair bit of integration on the back end, which is not the kind of thing you do with just this temporary public health measure.
Yeah, so we've heard a lot of concerns, of course, about the ArriveCan and, the utility of it. I think in your intro, you mentioned that it was meant to speed up the process, and everything we've heard about it is it's delaying travel into Canada, and in a significant way too. So what is it actually achieving is a really good and important question that we're going to be asking the government to answer on our end.
Is this being fought? I mean, I know it's a charter challenge, but what's really the key sections of the charter that you think are impugned by this?
I'll take that. So I think that one of the most important one is Section 8, which deals with privacy. That's a major concern. Another charter section is Section 7 and the 14-day quarantine. One of our arguments is that people are arbitrarily being detained arbitrarily for 14 days. We've had applicants who are fully vaccinated. There's no scientific reason, and we can't see any legal reason why they have to quarantine, and yet they've been asked to quarantine. So it's very arbitrary. And we know about the glitch in the ArriveCan in July, where 10,000 people who were fully vaccinated, who had no issues, were told by the app that they have to quarantine for 14 days. And then it took the government 12 days to contact these people to say, oh, this was a glitch, it was a mistake. So Section 7, Section 8, and another important section, which is dear to my heart because I was a former criminal defense lawyer, is the right to counsel. Because we have law-abiding citizens, some of our applicants included, who are being stopped, they're being detained by police officers, not by border service agents, not by FAC agents, police officers. They're being detained, they're not being allowed to leave, and yet they're not being told that they have a right to speak to counsel at that moment. That's really scary, really intimidating, and it's an issue that's been coming up with the quarantine cases constantly. So that's another very important issue that we're raising.
One of the challenges, too, with ArriveCan, as I see it, is that the government has offloaded some of the enforcement to airlines. So if you are wanting to get on a plane and go from, Heathrow Airport to Toronto or from Geneva, Switzerland to Montreal, Air Canada or WestJet or whatever will not let you board the plane unless you show that you've done the ArriveCan. So even for people that are willing to fight this, that would protest it at a point of entry, you're actually denied the right to even get to Canada unless you go along with this.
Well, we're getting a lot of conflicting information, and what we've seen too is just a lot of very differing cases and fact scenarios, and that's been incredibly telling as to what is going on. The fact that people are being denied entry onto an airplane outside of Canada doesn't seem to fit what the law says. My read of it, it says that the airlines are asked to notify people. There's nothing about not allowing people to board. So I have heard a couple of those stories, not as many. Certainly the issue that we're facing in this legal challenge is once they've arrived here, what's happening. And something I just want to add to what Sayeh was saying is a lot of these people are really good law-abiding Canadian citizens that are surrounded by these security customs agents, then public health officials. It's intimidating. Then they're being told, mandated to go quarantine. Then they're being given these hefty fines, and they're trying to do the right thing. In many cases, they're showing proof of vaccination in some cases. They're just trying to go about their daily lives and come into the country that they are citizens of, and really getting a hard time with that. So the stories are incredibly compelling, and unfortunately, that's what we're facing right now.
I know there's a bit of a pilot project. I don't know how widespread it is, that your customs declaration that you'd give to, I'm not bringing anything from a farm, or I'm not bringing anything over $10,000, that sort of thing, has been integrated to in some cases with ArriveCan. And this is where we could see it becoming more permanent. Is that something that you believe is part of the challenge, or is it just the COVID and vaccination aspect that you find particularly problematic?
I think the problem is we don't really know what data is being collected and how it's being stored and who has access to it. Because if it was simply about the vaccine, then people who are vaccinated could simply show their proof of vaccination and they could come in. There would be no issue. But this doesn't seem to be about the vaccine. It seems to be something more. And it's not clear what information is being collected, why is it being collected, who has access to it. And those are the concerns that a lot of Canadians have, including our applicants, the privacy issues.
We've seen throughout COVID, in the cases that have made their way to court, including some that you have fought. I'm thinking in particular of your, I thought, very good case against the hotel quarantine some time back, Sayeh, that the government has gotten a lot of deference and a lot of latitude from the court because of COVID. And obviously, the longer this goes on, the less acute that COVID issue is, or at least we would hope a court would see it that way. But are you concerned that this is another area where the courts will again just continue to let government take Section 1 of the Charter and justify all of this as a reasonable limit on our freedom?
I could take that one because I've experienced similar things with some of the cases I've been dealing with. And, we do understand that at the early phase of the pandemic, there certainly should be deference given. Where I have a hard time with the connection here is the longer we're into this pandemic, the more we should know. And I actually feel like we're understanding and we know less. And I don't think that we can continue, or the courts can continue to give deference when the information, the evidence just isn't there. At some point, courts are going to have to take a stand and say, you know, you need to, it's been now 3 years or now 4 years. Where is the information that is backing the mandates that you are enforcing?
Now, I know that some people have been fined thousands and thousands of dollars for not completing the ArriveCan when they enter Canada. Is your case proactive, or are you also dealing with some of the people that have had tickets that are challenging them?
All of our applicants have received tickets for either refusing to use ArriveCan, or some of them have actually made best efforts to use ArriveCan, and there was a glitch, there was a problem, and they were fined anyway. There was at least one applicant who felt really compelled to use the app because he was surrounded by police and he just didn't feel like he had any other options, and he was still fined because there was a glitch with the ArriveCan app.
If this were an option, something that you could do but didn't have to, would your case be insignificant in your view? Would your case be moot, or is your issue the existence of this app at all?
I think it's the mandatory nature of it and the extent that it's being pushed on people, and the fact that it's incredibly arbitrary. So when the court is going to look at whether or not this law makes sense, they're going to look at what kind of laws, mitigative measures were put in place. And in this case, we just see so many different, like I mentioned earlier, the cases are just so varied. Like Sayeh mentioned, somebody that there was a glitch with the program, so they get fined. My favorite, which is like a very unfortunate circumstance, is one of our applicants tried to get into the United States, was denied entry into the United States, is turned back into Canada, doesn't leave the country, and is still ordered to quarantine for 14 days. So just the wide variety of the cases, and the fact that there is no discretion given to the people, I think that's where it is. And that's going to, if it was not mandatory and if it was an option, then we would be in a totally different scenario. Definitely.
I think it's also worth pointing out that the government has changed its rationale, or at least the way it communicates its rationale for this at least a couple of points. I mean, I remember at one stage when they said that ArriveCan was authenticating vaccination records, whereas when you take a picture of your vaccine certificate, whether it came from somewhere in Canada or theoretically outside of it, it would do that. But it actually does no such thing. It just takes a photo of it and, looks, okay, does this look like a vaccine record, which is the exact same thing that a border officer could do, to your point earlier. So you are right when you say that this doesn't really align with the it's about vaccination thing. It doesn't align with speeding things up if we find it's actually slowing people down. Has the government really given, in its defense or response to you or in any other public record that you've seen, a definitive explanation of why this is so necessary that we cannot have an immigration and entry process without it?
They haven't, and that's because we haven't filed our evidence yet, and the government has not filed their evidence. I think that'll be interesting to see. But I think they're going to have some problem explaining, for example, why somebody who has never left the country has to quarantine for 14 days, or why does someone who's fully vaccinated have to quarantine for 14 days because they don't want to use this app. I think they're going to have some difficulty presenting that evidence to the court.
Just finally here, I'll ask you this, Eva. I mean, you have to keep hope, and you have to believe that judges are going to see the right path forward here. You're not of the view that government will do what they've done in some other cases here and say, okay, we're going to get rid of it, and then your challenge has to get thrown away because it's moot.
No, you have to keep hopeful that we are dealing with exactly that issue before the federal court, which is the same place that we filed the ArriveCan application on the vaccine travel ban. So as we're all very aware, the government has now suspended the vaccine mandate. And at the same time, or a few days later, the government lawyers filed a notice of motion saying that we want to strike your lawsuit because it's now moot. talking to any Canadian, regular Canadian, not lawyers, they're like, but the mandate is just suspended. And I'm like, yes, that's our biggest argument. So I think as well, given the national importance and the extent of the charter breaches that we're claiming, courts are going to have to listen to these arguments at some point and make decisions so that Canadians are aware of what the government can and can't do, and the government is also aware of what they can and cannot do. There's only so much that we could stay in limbo about as Canadians and our rights, and I think it's very important for us to have an open, transparent debate and a decision coming from a court that goes over all of these details and the evidence that, we put in a lot of time and effort for on that case, and we'll be doing the same for the ArriveCan case.
Eva Chipiuk, Sayeh Hassan with the Justice Center for Constitutional Freedoms. Best of luck, and thank you so much for coming on today.
Thanks for having us.
Bye, Andrew.
Thanks for listening to The Andrew Lawton Show. Support the program by donating to True North at www.tnc.news.